You have been listening to the closing arguments in the Lindsay Clancy case, the case that has taken the nation by storm. The closing arguments have concluded. These are the final instructions to the jury before 12 main jurors break away to decide the verdict in this case. You've been listening to the defense make one argument, Kevin Reddington, and Jennifer Sprague of the prosecution make another. Mr. Reddington saying that Lindsay was a good mother affected by postpartum psychosis, whereas the prosecution says these actions were deliberate, methodical before, during, and after, laying out the evidence. Those are the two arguments in summation. We will soon get to Josh Ritter, who is outside the courthouse, Donna Rotunno, and Jonathan Turley. But first, this is Outnumbered. I'm Kayleigh McEnany. Joining me today, Laura Trump, host of My View with Laura Trump, Cheryl Casoni, Fox Business anchor and host of American Dream Home on Fox Business, Kennedy, host of Kennedy Saves the World, and David Webb, Fox News contributor and host of the David Webb Show on SiriusXM Patriot. So we'll begin with our experts, our attorneys outside the courthouse. Josh Ritter is there. Josh, we heard from the prosecution laying out that before, during, and after, Lindsay had rational decision-making, a very different theory of the case than the defense. We know that this is a very high burden of proof. Jonathan Turley said earlier it's the best place to be a criminal defendant is in the state of Massachusetts, particularly when you're considering this charge. Do you think the prosecution made their case in the facts matching the law?
I got to say, I think the prosecution's closing arguments were very effective, surprisingly so. I did not think that they would be able to make as convincing an argument as they did. And the reason why is they addressed the two weaknesses I think that the prosecution had in their case. The first was this idea that they had dismissed Clancy's medical illness full out. In their opening statements, they'd almost made it sound like they didn't believe a word of her having any kind of postpartum depression, postpartum psychosis. They actually embraced that to some extent. They were sympathetic to her. They understood what she was going through and that sickness that she was dealing with. But their point was, in spite of all of that, in spite of her intrusive thoughts, in spite of her psychosis, she still had the ability to distinguish between right and wrong. And I think they nailed that issue. The other thing that they got into was motive. Motive was a big question for the prosecution. I think they struggled with that. Well, they actually provided one in their closing arguments. They said, this was a quote, they said she was depressed, she was exhausted, she was done. Now, that might not be all that convincing to everyone, but at least it provides something for jurors to hang their hats on as to why this mother with no criminal history would out of nowhere appear to be a loving mother for all of her life and then do this nightmarish, horrific thing. I really feel that the prosecution, if this was coming down to the wire and convincing jurors in these closing statements, I really feel that they did their job.
Donna, to the first point that Josh made, there was an acknowledgement. The prosecution began by saying all women do deserve health care. They went on to say this doesn't mean she wasn't struggling. She, Lindsay, did have depression. That was an acknowledgement from the prosecution and a shift from the beginning of the case. Your thoughts on if the prosecution made their case?
Thank you, Kayleigh. I absolutely believe they did. And I really am surprised watching this today because I was expecting the defense to come out in a much stronger way and lay out a more compelling case here in closing, given the testimony that we have heard in this trial. And I do think they missed the mark. And the state did a very good job. The Commonwealth of Massachusetts did an excellent job laying out their theory of the case. And whatever you think about this or whatever side you think it should come down on, they did their job today. She came in with a much more conciliatory tone. She was very measured and calm today. She did not come across as somebody who did not have sympathy for Lindsay Clancy. I think Josh is right. She did embrace some of the issues that they seem to have sort of discount before. So I'm very surprised, actually, about the way I feel today because I thought I would feel differently when this was done. I'm curious to see how much weight the jury will give these closing arguments versus the other bits of evidence and pieces of evidence that they listened to over the course of several weeks. But they did their job.
Donna, you noted the prosecution laying out the timeline of the case. We want to play that for our viewers in case you missed that. There was this moment.
You start to see the planning at about 4 o'clock in the afternoon. When this is on her phone, you can see her search for Miralax, kids Miralax at 4:02. And then a little while later at 4:13, you see her search for takeout from 3V. And then immediately after, she does the Apple Maps search to see how long it takes to get to 3V. What she needed to know was how long specifically on that night it would take to get there. Because she knew she would have a limited amount of time to do what she wanted to do. And what she had decided to do was to kill the children and then kill herself. And so she needed to know, not generally, but exactly how much time will I have. And then obviously sees that that's not enough time. So then she searches CVS. And not only does she search CVS, she calls them. Calls them and asks them if they have kids' Miralax, and they say no, but they have Pedialax and one other medication. And then she asks, is it in stock? Because she needs to know not only what they have, but is it in stock? Because she's adding to this errand that she's sending Patrick out on. And she has to make sure she's not interrupted. She doesn't want that call at 5:33. She wants him to go to CVS and have the medication there and get it and then go on to 3V so she has time to do what she needs to do. So that's why she's calling to see what they have and make sure it's in stock. It's a level of planning there and thinking and decision-making that Dr. Satoff referenced.
The defense arguing back that it was a moment of psychosis in an episode that happened during that discrete timeline. Cheryl, I know you have a question for Jonathan Turley.
Yeah, Jonathan, you know, in that soundbite we heard, they were so focused on the planning, the prosecution was. At the same time, you know, looking at the actions before the killings. Having said that, though, isn't it true, and is there other cases, is there precedent elsewhere on the law books that show that a psychotic person can still plan something methodically and still carry something out and still be diagnosed with psychosis in this case?
You most certainly can. And some of the defense experts really sort of drew that out for the jury. You know, this was, I'll join my colleagues in saying that I was astonished by these closing arguments. I felt the defense lost ground today in a way that I would never have imagined. They had created a very coherent narrative in the trial and just completely trashed it with this rambling closing argument. The prosecution, conversely, really cleaned up their act. I mean, they brought their case together. You know, I tell my students all the time that these trials, attorneys tell two different stories, and you got to protect the spine of that story for that jury. The prosecutors finally got around to completing that story and said she wanted to kill herself. And she decided that the children had to go first. And she was struggling with depression, but she shows that she had these cognitive, controllable thoughts in all the actions that she took. It was a very good closing argument, and it was the one thing they needed most certainly. There was also mistakes by the defense, you know, turning his back on the jury. He used these coins to make his point about his arguments. Well, the prosecutor really turned that on him, used his own props and removed the coins one by after another, saying, well, there goes this point. Those are just tactical mistakes, but the prosecutor had a very good day on their last day.
So noting for our viewers, you're still watching a live feed from the courtroom. The factual arguments are done. These are jury instructions, and the slip that the judge is holding, that is a verdict slip that the jury will look at as they enter their deliberations. Kennedy.
Donna, I want to know from you, because you and your two fellow attorney panelists have expressed some concern with how the defense presented the closing argument. How much impact do these arguments have on a jury? Do they have what they need? Because, I mean, this has been, I can only imagine the thoughts and conversations they're going to have, considering the thoughts and conversations we are having as mothers. And, you know, culturally, this trial has eclipsed so much. So how important are those closing statements, considering that the defense kind of fumbled?
Well, I think you're right. They did fumble. And when I look at this, I think about, okay, the jurors are going to go back, and they've been listening to this evidence for weeks, and they have been making their judgment calls as they go. And even though the judge tells you you're not supposed to draw any conclusions until you've heard all of the evidence, I mean, you hear all of us talking about it every day. You know those jurors are going home thinking about things the way that we are. So some, I'm sure, have made up their mind to a degree when all of the evidence was completed, and they sat there today with whatever slant that they felt that this this case was going. So do the arguments help change that view? I think in some cases, my answer would be not really. But I think in a case like this, and we've been saying this for weeks now, the evidence in this case for both sides can be argued in the opposite way for both sides. So pieces of evidence that are positive for the prosecutor, the defense could turn around and argue that it's possible and very positive for them. So this is a very different type of a circumstance. So I do think that the closing arguments in a case like this matter more than they do in some of the other cases that we talk about, because there really is so much involved here. And what I think the defense did was the defense did not capitalize on the arguments that were best for them. He needed to go after the burden of proof in a much stronger way. He did not do that. And then he needed to highlight what the state could not do with that burden of proof. And this just did not feel well planned. It did not feel like he had a path to take the jury to not guilty. It just was a rambling closing argument with a good command of the facts, but he did not present them in a way to explain to the jury why his facts and the facts that are better for him mean that they should find her not guilty by reason of insanity.
Josh, this is Laura Trump. Just want to ask you, I think it was really surprising to a lot of people to find out this jury was not sequestered. This was a very high-profile case, a lot of attention given to this. I think a lot of people expect that in these situations, a jury would be sequestered. We did hear the judge there, as he was giving instruction to these jurors, telling them some things they could do and couldn't do with their phones. What happens now, though, to a non-sequestered jury? What are they able to do? What aren't they able to do as they're deliberating now in this case?
We have to put a lot of faith in them, that they're just going to listen to the judge's instructions. I don't know about you, but anytime I open up my phone within the last week and open any kind of social media app, I'm just inundated with coverage on the Lindsay Clancy case, with everyone weighing in on their opinions on how they think this thing is going. The jurors are living in that same universe. And so how they're going to just avoid their phones and avoid any message is beyond me, but the judge has asked them to do that. Here's the other thing, though. They know the kind of attention this case is getting. They've seen the camp of cameras set up outside of the courtroom that I'm looking at right now. They have seen the line of people waiting to get in. That's a crowded courtroom. They know that all eyes are on this. You have to imagine that's playing some role in their head. It's just we can do our best to instruct them to ignore all that outside noise, try to pay attention to the facts and apply it to the law as best that they can.
Josh, and you're outside the courtroom. As you were speaking, we were watching some live images. The judge was actually swearing in the jury. There was a brief sidebar that took place as well. So any moment now, these jury deliberations are going to officially begin. David, I know you have a question.
Yeah, thank you. Jonathan, my question is for you. It's David. On the issue of motive versus mens rea and the strategy in making the argument, and a little bit to what Cheryl asked earlier to add to that, what would have been a better strategy, you think? You argue the motive, the opportunity, the means, the actions, the timeline as laid out by the prosecution, or you defend against mens rea?
Well, I think that the defense did a very good job during trial. That's why some of us are sort of surprised with this rambling closing. There was greater clarity and coherence in the trial. In some ways, and it's a very odd thing to say, but the horrific aspect of the crime works into the advantage of the defense because it's an unthinkable act. It's against nature. And that jury wants to understand this narrative. They want to understand the answer. They want to understand why a mother would do something like this. Most people look at this and say, look, you have to be truly in the holds of something horrible to commit such an act, to kill 3 of your children. But the case also, in terms of mens rea that you raise, David, we have this last minute change where the court is going to allow the jury to consider manslaughter. And this was at the request of the defense. It's a smart move because it lays out the possibility of a compromise verdict. And so it gives you a safety net. If they don't agree that your client was not in control of her thoughts and actions, then they could always go for that lesser crime. The problem is that if she was in control of her thoughts and actions, it's pretty hard to imagine this could be manslaughter. She strangled her 3 children. I mean, this wasn't like a hit and run accident. I mean, if she was sane, she is a murderer. Yeah. So it's an odd option for the jury. But the danger is that if they don't agree, if they decide that she was sane, that sentence might drive the verdict, that they may view manslaughter as a compromise to try to get her less jail time.
Be sure to like and subscribe for all the Fox News latest on YouTube and catch full shows streaming now on Fox One.